Okay. I'm opening the continued committee of conference on House Bill 609 and present myself, Chair Terry Roy, Rockingham 31. And if you would introduce yourselves, please, House members.
Representative Jennifer Rhodes, Cheshire District 17.
Representative Erica Leon, Rockingham 13, Derry.
Representative Kathleen Paquette, Hillsborough 25, Manchester.
And my Senate colleagues, please.
Senator Darrell Abbas, District 2.
Senator Tara Reardon, District 15.
Senator Tim Brown, District 2.
Thank you. And where we left off yesterday is we were trying to find some language that we thought would be a good compromise for both parties. I believe that language has been circulated, has it? I'll turn it over to Representative Leon to discuss where the language is at.
Thank you very much. I do have some language. It was sent out in some emails this morning, but I do have an OLS draft and a summary here that I can hand out to everybody. I'll just pass it along.
And if you could, for the public, go over where we're at with that.
Absolutely.
Oh, yeah. This
Okay.
two dueling drafts.
Yes.
Oh, wait, we have two different, same version though.
Probably not.
No.
Well,
Yeah. Yeah. My understanding is that we're all trying to work to a solution that protects everybody's rights, and we are working towards that finalized language. We have two different drafts that we need to compare, see where the differences are. I can walk through what is in the draft that I've brought forward. Hopefully we can have somebody speak to the other draft. Oops, could I get one of those? I think the one that I had. Yes, thank you. And then we can look through and see what the differences are, see where we have some points of, well, not even necessarily figure out the points of agreement and all of that. We'll figure out the entire package, but see where right now we're headed in the same direction. So I can walk everybody through this amendment. This one is 2107H. So one of the things that it does is that it just trims this list. We were adding stun guns, tasers, pepper spray devices, and other self-defense tools. And if we're making sure that there's any sort of private right of action, having an undefined term that's not in statute just introduces complications that we don't need when most of these tools are already defined in statute. So in 159.26 in paragraphs 1 and 2, which are existing law, the only changes there are that list of personal defense tools. Then if you look at section 3, that is a new one that then brings it basically gives more details and clarity about what happens with political subdivisions in the state, because it's already existing law that they cannot enact ordinances that are contrary, that would regulate firearms, ammunitions, et cetera. So what this does is that it declares the general court supremacy over the regulation of these tools, basically saying that because being a Dillon Rule state, anything needs to come through the legislature before these choices to limit people's rights happens at the local level. It allows for a suit for damages of violations of preemption law. It also says that just because council told you that it was okay to restrict guns in the local park, if there's not statutory authority, that's no defense, because we do try and write our laws so that the average person can understand them and read them. And then it leans the law to allow all of the current protections for elected officials that we already have in statute. But if it ensures that if somebody is willfully not complying with this, willfully and knowingly pushing ahead with something that they absolutely know is against state law, that there is recourse for that. And then also if somebody were to file a lawsuit saying that, no, you cannot prohibit guns from my local park because that's not allowed by statute. If they don't fix that until the lawsuit is filed, it says that you've won in that lawsuit. Then moving to section 4, it clarifies the role of the legislature in the oversight of state agency rules, regulations, and policies. I know the idea of talking about rules when it comes to the Second Amendment has been very touchy out in the public and in the community. But the fact fact of the matter is, today, agencies can make rules regarding firearms and other personal defense tools. If we don't pass anything, that will be unchanged. There are many, many rules already in the body that exist around firearms. Most of those are specifically statutorily authorized, but not each of them. So right now, there's also some that are currently exempt from the rulemaking policies. So right now, if a particular department says that their drivers, when they're out dealing with volatile people, cannot carry a personal defense tool, even when they're miles away from anybody else, if they're disarming people when they may be in a vulnerable situation, they won't be able to do that without getting statutory authority. It would sort of pop the bubble on some of the exemptions for the internal policies when they relate to firearms for state employees, so that we can ensure that there is transparency, and we can also make sure that anything that needs to happen is moved into statute before the effective date. There's a 3-year sunset on those policies and rules, which gives us a couple of different cycles in order to say, perhaps this part of the police standards that deals with an emergency response should be carved out into statute, that we're going to specifically exempt that from this process because transparency would be to the harm of the people and to the harm of the state. So it would allow us the time to get those particular carve-outs filed next year once we hear from everybody about which specific parts need to be protected for safety. But it wouldn't allow things that tell you that when you're working this job, you can't carry concealed. And you can't do this if you're not in a sensitive area.
Can you give us an example? Because you've gone over a few things. So when you say state employees that are in the middle of nowhere, are you talking about potentially like plow drivers who are out at 3 in the morning on the road?
Yes, and that sometimes run into volatile people.
Yeah, I
Yes.
saw a video once.
I saw a video once too. We should make sure that plow truck drivers can defend themselves if it does come to that.
Yeah,
Yes.
no comment. So what about the other part you said with regard to the exemptions? What do you mean by that? Give us an example of that.
So currently in the rulemaking statutes, there's a whole list in RSA 541A21 that exempts different things from the rulemaking requirements. Some of those are around corrections procedures. So if there was a rule that said that corrections employees could not possess a firearm on any of the state property, including in their vehicle, then that would mean that somebody who may have been guarding somebody in prison who's now out would be disarmed on their way into the corrections department to go to work to their job. These are people who put themselves out there in order to protect public safety, and we should make sure that there's no policies that would disarm them and make them vulnerable for doing the job that we ask them to do for the state. And then there's severability, just to make sure that if there's one part that's a problem, that's section 4. And the one thing that I think really is the strongest part to ensure that rules follow the law is section 2. We've been discussing the limitation on rulemaking when it comes to firearms and other tools. There is a list already existing in the Administrative Procedure Act, RSA 541A22. 3, which says what the agency shall not by rule do. This is where we flag if there's a fee increase, a fee that hasn't been authorized by statute, if there's a penalty that's not authorized by statute. This is something we see in JLCAR constantly. And so putting the regulating the sale, purchase, ownership, use, possession, transportation, licensing, permitting, or other matters relating to firearms, firearms components, ammunition, firearms supplies, stun guns, tasers, pepper spray devices, or knives, unless specifically authorized by statute, would mean that that trigger already shows up if any rules are submitted that violate that. That's not left to the public to find, but becomes part of the bill review process in the Administrative Rules Department. But because when statute is passed, any rules that are in violation are then invalidated, this would only apply to any rules adopted after July 1st, 2027, to allow the rules that are already in process to continue through. We'd obviously flag something if it would need to be renewed again in 3 years, subject to the earlier section of the bill. But it would also identify times that perhaps this is a good reason to have a regulation, and there would be one full legislative year in order to get a legislative directive to say that in this case, you may regulate X, Y, or Z. If the general court, who has the authority, believes that it's appropriate, it would be specifically put into statute and would be perfectly fine in rules. So hopefully that summary worked. I'm happy for any questions or to hear what the other draft is.
Yeah, please, my Senate colleagues would weigh in. Representative
Could I-
Abbas?
Can I ask just two questions? And this is actually in both versions, so I want clarification on. One of them is, so on the Senate version, it would be lines
Sorry.
12 to 13 on page
Sorry,
2.
Senator, could we get the Senate version? We haven't seen that one.
We sent it down. You have one with my name on it and Senator Abbas's name? And Representative Leon, in the amendment that you prepared, it's page 2, lines 17 and 18.
Coming down.
Page 2, line 17, you said?
17, 18 of
Okay.
the House version.
Okay.
The Senate version is page 2, lines 12 and 13. But it basically says if the local municipality or whatever takes some type of remedial measure and basically changes a policy that was in violation of this law while a petition's pending, it says the petitioner or plaintiff shall be considered a prevailing party. Do you mind some explanation? I mean, it looks like normally remedial measures aren't.
I can explain. What happens in constitutional civil rights litigation sometimes is that a party will go all the way through the process and get right up to where they're about to get a judgment from the court. And then rather than lose the case, the municipality changes its rules. That happened sort of most famously, I can't remember the name of the case, at the United States Supreme Court. It was the case that New York State brought against
Oh, I know, and the court said, no, we're not dropping it just because you changed.
right, that was part of the concern. But New York changed its law after they had litigated it, been through the circuit courts, briefed it in the Supreme Court. And it's to prevent that from happening. It's to make sure that if somebody goes through the trouble of finding a statute unconstitutional or a rule unconstitutional, they're still available to get attorney's fees.
There's no attorney will take the case if they know that they're going to do that at the end.
Right.
Got it.
And I would also mention that it's my intention that when this is signed into law, I will go through and notify anybody that I can flag as in violation of it so that people don't find out when there's a lawsuit filed.
I'm sure it will be spread well very quickly to the municipal association.
Yes.
And the other question I had, and this appears in the House version on lines 19, on page 2, lines 9 to 11. It's also in the Senate version. It basically, if it's willful or knowing, it would potentially multiply the damages. That's fine. But it says, it shall not be a defense under this section that adopting or enforcing any charter amendment or provision or ordinance or bylaw that the local government was acting in good faith or upon advice of counsel. If I was just kind of thinking, if they're the victim of bad legal advice, which is how that would work, is that something that,
It seems like everyone would claim that. If that was an availability, they'd say, well, the lawyer said.
I think it's mostly a belt and suspenders proposition. It's not a defense to a constitutional or an ultra various claim that you were following somebody else's advice, in this case, an ordinance. An ordinance either would or would not be consistent with what the law requires and what the Constitution requires. Advice of counsel is not a defense, and this just clarifies that.
The counsel issue only comes in when you're appealing a bad ruling in a criminal case. In other words, I had ineffective counsel, but that doesn't work in civil litigation.
but it might be a
Normally.
mitigating factor for the willful or knowing.
It could be.
And that's why I'm asking, like, could you claim, like, well, clearly we violated this, but we were operating on the advice of counsel. Was it willful or knowingly? Would you be able to raise it then? I mean,
It wouldn't be knowingly, right? Because you didn't knowingly do it. You were told that it was okay, so you did what you thought you were.
Yeah, some things we have to leave up to the judge, and I think
it's a
that's.
mitigation defense.
Yes,
I'd say.
it matters of mitigation and extenuation for the judge to consider in her ruling. So, next question?
Mr. Chair?
Yes.
So, to Representative Leon, so the language you put here under the Administrative Procedure Act 541A, did you run that by Doug?
I have a call into him and I'll ensure that that is in fact solid. That was just a recognition that while we do everything in this section, it's going to be a lot harder in order to make sure that this actually gets flagged in the system.
So one of the reasons I got reassigned to this committee is because we've kind of moved this into Jalcar's purview, and I'm the chair of Jalcar. My concern with this whole section that you just raised is that we would not have the authority to even approve a rule where, by the way you've written this. So if an agency came in and said, we want to regulate tasers, we either want to allow them or not allow them or whatever, we want to allow our people to carry them or whatever they're going to do to, or we want to prohibit it in our building, whatever they want to do. By the way you've written this, you've amended the Administrative Procedure Act, says the agency shall not have a rule, period. And it lists you can't regulate sale, purchase, ownership, use, possession at all. So, and Jalcar doesn't have the right to overwrite the law. So the standing law would be is they have no right to make any rule whatsoever on anything, never mind bring it to Jalcar.
Well, thank you. I thought that that was the intention of the Senate amendment in order
think
to
you-
have, no, not this one, but as it was passed, was to limit that in those cases.
think
And that
the
it was
intention-
limiting the ability of Jalcar to, limiting the ability to have rules that violate this.
So if I can speak,
Yeah, go
I
ahead.
think the intention was to make sure that any of those internal rules is what we're talking about, which technically we don't look at now, would now become Jalcar-based rules and would have to go to rulemaking and be voted on by Jalcar.
If I may, our intention is that if there are going to be rules, that Jalcar cannot approve the rules unless they are in compliance
With.
with this statute.
Correct.
So we need language that says that if if agency brings a rule that hits on one of these protected topics, Jalcar cannot approve it if it violates the intent of the statute.
Well, I'm pretty sure that's what the
Or unless there's a clear delegation of the authority to make
correct
the rule.
under by
That's
another
what-
statute. I
right.
think that's what the Senate version does. The House version, the administrative rules section, makes it so it's an absolute. They can't even write a rule.
What section are you referring to?
Section 2 on page 3, starting on line 12, the Administrative Procedures Act, and that section, on line 13, it says an agency shall not by rule, and then you go down to the new section, she's adding letter I, create any kind of regulation.
Yeah.
And my understanding was that there may be a reason for an agency to provide a regulation. However, if they're going to do it, they have to bring it to us and we have to approve it. And it wasn't an absolute prohibition on any rules. It was a mandatory requirement that they show up in front of Jalcar and prove their rule.
We've had some conversations with regard to the rules and whether or not, we would rather an agency put it in statute if they, instead of a rule. But when we have 3 or 4 different devices or items that we are prohibiting control over, I can think of hundreds of situations throughout the different agencies where one of these items would be problematic in a workplace. Not necessarily because we don't like guns, but because having one when you're climbing through a pipe, for example. I mean, there's just so many different. So if we were to do it that way, we would have to write 100 statutes. And good luck to the agency.
Well, I don't think the issue is statute. Again,
Well, I think that was, the Senate amendment, I think originally was intended to recognize that the legislature can't write all those statutes and pass them all. It'd be, you do nothing else.
Right.
But that there did need to be more discipline imposed on firearm regulation through more specific delegations of authority by the legislature to the agencies.
What language do we need, though, to make sure that Jalcar cannot approve a rule that would be contrary to this statute that says we don't want you stripping our state employees of their
But
rights?
isn't the mere fact that Jalcar taking action, whether approving or not approving, like by them approving the rule, and let's say the rule is restrictive, I mean, it still went through Jalcar. So I think as it's applied, it would resolve that.
Well, no, if Jalcar approved a rule that said truck drivers can't carry firearms, that's not in keeping with the spirit of the statute.
But even under the original bill, the legislator would have been able to approve such a rule if that they so chose to do so. It's the same process. It could still be done. It's just whether, you and I may not like that, whether it's done through Jalcar or by the legislative process, but it's still being done.
Right, but if we don't put something in there, then this whole thing is an exercise in futility because we're back at square one. Because the agencies are writing rules right now that say you can't carry a firearm here, or you can't carry a knife here.
if I can make
Yeah,
again,
please.
the problem is that the current rules that they're writing have no oversight in Jalcar. And the reason being is they're internal rules. Generally, the rules that come in front of jail car are what we call external rules, or the rules that face the citizen.
Yeah.
So how a citizen interacts with an agency, not employment rules. We don't see those. What we're intending to do here is say from now on, if you're going to write employment rules about these topics, they must come before JALCAR and get legislative oversight.
Okay.
Right? So it's not an absolute prohibition, but it's now, right now, we have no say in what they do for rules. The idea being, my understanding, and Rick, correct me if I'm wrong on this, but my understanding was we want legislative oversight. If they're gonna, to your point, there may be a reason agency says if you're crawling in a hole, don't carry your gun, right? And there's a legitimate reason not to do that, and they want to write a rule to say that, but that rule should come before JALCAR.
And if you are
So-
going to carry a gun, it might have to be a retention holster.
Well, whatever.
Yeah, yeah.
So this is a very different, this is a very different understanding than what I had of this. When I read what we have as 4B in both the House and Senate amendments, that says no rules, regulations, or policies shall be adopted except under express authority delegated by the general court pursuant to the statute, ...
Yeah.
shall identify the statute expressly authorizing rulemaking related to the sale purchase. To me, that says that JALCAR can't approve something that is not statutorily approved. We can't just say, you know what, I think not carrying a gun in a tunnel is a great idea. Let's go ahead and approve it. The reason why there is a glide path and a ramp to this adoption is to identify any of these and say, you know, in these categories, there can be an employment rule when, you know, that there needs to be a retention holster when you are upside down or you're crawling through something small. I recognize that this brings more work on it, but I think that the rights of state employees are worth us going through this process. And if the intention of this is to allow JALCAR to rubber stamp something that would not follow the rest of this, I'm not
Well, that's why I'm talking
that's something I
about-
disagree.
That's why I'm talking about language that ensures JALCAR doesn't just say that sounds reasonable without first bumping it up against the statute that says the presumption is that state employees enjoy the same rights as every other citizen. Now the burden should be on the administrative agency why they have to overcome that, and only then could JALCAR approve such a rule. I don't think it's reasonable, though, to say we need a statute for every single potential situation where an employer in the state has to say, okay, you're an electrician, no tasers, please, while you're in this position. You can have it later. It gets so complex. We would spend years just trying to pass all the legislation. So I think that this is the very nature of why you have rules. But to your point, I think that there needs to be a clear, hard line. You cannot approve a rule if it's contrary to the intent of the statute, which is that state employees shall be presumed to have the same rights as every private citizen. Does that make sense?
That is my intention. It's not my intention, though, to allow some backdoor. And I'm not saying that you're asking for backdoor rulemaking, but I'm also talking to the concerns that I've heard. I don't want it to be able to just go by JALCAR and have them say, you know what, I think that makes a lot of sense. Let's just go ahead and proceed with this. The reason there's the 3-year ramp is that if we do end up running into some of these situations, this is something we can address. JALCAR generally puts forward some legislation to address what has come up in the rulemaking process in order to make the necessary changes in order to be able to affect the goals that we put forth.
Mr. Chair, can we take
Yeah.
a 5-minute recess?
Do you have any?
It would have to be a break.
No, no
break, I
reason. Yeah,
apologize.
that's
5 minutes
okay.
break.
Unless I say
He
it doesn't-
didn't say yes.
If I didn't say it, it doesn't matter. Do you have anything you want to say to before we take that, so that we can take that with us?
I do. The thing that I think addresses the concern that's being raised is in the Senate version, page 2, starting on line 26, which says the agency may not rely upon implied authority and shall identify the statute expressly authorizing rulemaking related to the sale, purchase, ownership. So that is, I think, a heightened reading being imposed on JALCAR in this field.
So they can't approve it unless the agency can point to what statute says they can actually do that.
Exactly.
Yeah, but absolutely.
So one of the concerns that I realize is kind of a null and void is when you hear somebody say, oh my gosh, somebody's going to put a firing range, you know, right next to the town hall. And that can't happen because it's already prohibited for all these other reasons. So when people are saying that, that's going to happen if this happens. No, it's not, because it can't happen. So what I'm hearing, if I'm hearing this all correctly from the different sides, is if there is going to be a rule that is going to be adopted, they're not given the authority to just make a rule because they want to. The rule has to fall within
The statute.
the rule that's already saying, kind of, as you just can't put a firing range there because you want to, because this has changed. Is that
That's basically correct, yes.
okay? Thank you.
Okay. All right, so you guys want 5 minutes?
Yeah, 5 minutes.
Yeah. Actually, make it 10.
Okay.
It's going to be a minute.
We have to go to a different floor.
Okay.
We on break.
Who's gonna go next door? Next door.
Hey, what section is that again? Reference on House Bill 609. The parties have met, and I think that we are at a position where we have an agreement in principle. We're working from the latest amendment given to us by Senator Lang, which is 2106S Sierra. And what we're going to do is I'm going to turn it over to Representative Leon, who's been working tirelessly to make sure we have good language. And she's going to go through a few suggestions and concerns. But we, after having met last and becoming cognizant of the fact that no rule can be made that is not pointed to an enabling statute, gives us, that takes away a lot of concern we had about just agencies writing whatever they want and gel car rubber stamping it. So with that, I'm going to ask Representative Leon to please go through line by line on 2106, what our concerns may be.
Thank you. I will go through that. Thank you. I will go through that. There may be one or two that I would just bring up in real time to see if it changed from the earlier draft that we had worked from. Okay. So the first is around removing other self-defense tools. If that's something that the Senate wants to keep, I was just worried that that just is a fuzzy term. And if we're looking at a private right of action, I was looking to more narrowly define it.
So my only point with that is, I mean, it's not a deal breaker, but the underlying bill had other self-defense tools in it that the House originally passed. So that language was already in there. In the Senate, we left it in. So
We talked about it, and we're happy to put it back in.
Yeah,
If that's what that was the position of the House, then that's what we're going to go
Yeah,
with.
we can do that. The prime sponsor was fine with removing it, but if we want to continue with it on, that's fine with me as well. I don't really think that it's a large vulnerability. I just figure when we're doing it, you know me, I like details.
No. Well, again,
It's a flaw,
I'm going
but
to go back
that's
to
okay.
that's what the House position was, so that's what we like. Okay.
Okay.
Next.
And then the next is on in section 3. So that starts on line 22 of the Lang amendment. Quite frankly, when I read through this list and it's just the 3A, 4A, knowing which one that I'm in is challenging. That's why in the one that I put in, I proposed the introductory paragraph for section 3, for paragraph 3, saying to the extent consistent with federal law. It restates a lot of it, but relative to, this is relative to political subdivisions, although I guess I didn't say political subdivisions, but it's just clear that we're setting these terms, and under those terms, what limitations exist. So the question is if an introductory paragraph is something that's acceptable or not.
Could we do that? Put an introductory paragraph to state the legislative intent of that paragraph, that section?
So if we insert that paragraph, section 1, that starts with to the extent consistent with federal law and ends with therefore the following provisions shall apply on A, that whole paragraph, we insert it above your Roman 3A, would that work?
Well, the problem with that language is it says the general court exudes exclusive authority and jurisdiction over the regulation of the sale. It doesn't say that the general court can delegate that authority to GELCAR or anybody else. So that was the provision in the original House passed bill that made it appear that the intent was to have the legislature do everything.
Could it
and that the
say-
Senate was moving away from.
Could it just say, and only the general court may delegate such authority?
Something along those lines could work.
I may have an alternate introductory paragraph. I'll
already
get
in
the
paragraph
specific
1.
language, but the following provisions shall apply to political subdivisions and those that are relative in that paragraph 3, just so that people know which section to go to, giving them a roadmap.
In other words, that section only applies to political subdivisions and not employers of the state, I think is what we're trying to.
Mr. Chair, if I may.
Yeah, go ahead.
So again, I think Senator Abbas here has the point that I think the language you're talking to is already in the start of section 1 of the bill. To the extent consistent with federal law, the state of New Hampshire shall have authority and jurisdiction over the sale, purchase, blah, blah, blah. That language is already there, so we're just going to repeat it.
It actually adds the word exclusive, so we could strike that exclusive authority if that works. So that it would read, to the extent consistent with federal law, the general court asserts authority and jurisdiction over the regulation and sale. Although that exclusive
Where does it
was-
show exclusive in the Lang amendment?
It's not, this is the introductory paragraph that is not in the Lang amendment.
No, so
that-
we're talking about the Lang amendment on paragraph
Yes.
1. It has
Oh.
the language you're looking for already there.
Correct, except the one in paragraph 1 doesn't have exclusive. Sorry, the one in paragraph 1 does not have exclusive, just as you said. That was in paragraph 3 in the introductory. If we don't want to put in an introductory paragraph to have a roadmap, that's fine. I just thought that that was easier for people to read. I'm willing to drop the addition of that introductory paragraph.
I agree with you, but if we're saying the exact same thing, just 2 paragraphs above, I think it's pretty clear. I think it's pretty clear. In the subject matter of paragraph, section 3A talks about it being a public entity or quasi. I mean, I think it explains subdivisions. So if we're okay with dropping that.
Then I can drop the introductory paragraph. Then moving to 3A, the Lang version says no person, public official, public employee, political subdivision, or any other public or quasi-public entity shall. I was concerned about the person and then having public official or public employee without stating that it's in their official capacity. What we're looking to do is restrict state actions, not restrict the actions of individuals or those who are public officials or public employees in their personal capacity. So I don't know if I'm overthinking things as far as that, but I wanted to see if it was more clear to say no public official or public employee in their official capacity.
Do you think we need to add that?
I don't think you need to add that. Official capacity doesn't change much, really.
Well, so if
Especially given the 3 provisions of RSA 31, I think it's 104 to 106 that govern defense and indemnification of public officials for acts they take.
Well, no, I think what we're saying is, okay, so I'm a public employee or official. I also own a business. My business is no firearms in the business. Could someone go to this and say, well, you can't do that because you're a public employee or public official?
I think that's a stretch of the reading, but
Well, we're just throwing it out
It's
there.
certainly not anybody's intention, I don't think, to do
No, no,
that,
no.
obviously, right?
Right, but do you think it's a vulnerability worth adding just the words in their official capacity?
And to remove person, because I don't know if that's more, I guess we'll have that part separate from the official capacity.
when we start using the language official capacity, I think we open a lot of other doors that's for a much larger
You
conversation.
talk about federal 1983 claim type stuff?
Well,
But when you sue a public official in their official capacity, it's effectively a suit against the government entity.
Yeah.
And that's the way it's treated.
And they
And I-
fall under that umbrella of protection.
There's immunities that apply,
Yeah.
right?
So it's better to not say that because then you can
Well,
sue.
it's different to not say that. You got to
Yeah.
decide what's better.
Well, it depends who's representing who.
Right.
Well, and to clarify the legislative intent, the intent with this is that it's when the public official or public employee are doing it generally in what they do about regulating public entities and public things that they have responsibility over. It's not talking about if I, as a public official, have a business and I, for some reason, decide to restrict firearms, since that's not my style. But if I were to, it would not be the legislative intent is not to prohibit that, correct?
Right. Yes. of
Okay.
course.
So I guess we're good on the legislative intent there. The question is on person.
I
Is
had
the-
the same thought about the word use of the word person. It could create the impression that this just applies to everybody who might, in their private
Yeah.
capacity, exercise their property rights however they wanted to relative
Yeah.
to guns on their property.
So we strike person?
I think you could.
Okay, let's strike person.
So we'll strike
So it just
person.
says no
No public
public
official.
official.
Yeah.
Go from there.
Public employee. And I think the words public before each one of those things, it clarifies that it means what they're doing. Okay, next.
The next section is on D, so 3D. It's probably belt and suspenders, but just because as people are reading through, they're probably not going to search and see that it's RSA 31-104 and RSA 99D that do provide for the process about whether or not the municipality, whether or not they're protected, or if it is pierced by the willful intent or the negligence as far as those statutes. I thought it was more protective to specify those statutes, although I recognize that except as required by applicable law also fits.
It's broader. It may scoop in other circumstances not covered by those statutes.
And we may write another statute that then we'd have to go back and adjust this. So I think leaving it broad is probably better.
Okay, that works. You know,
Not-
I'm getting into the details,
No,
but that doesn't mean my detail is always right.
We appreciate your attention to detail. Okay, next.
The next is in 4B. In 4B right now, the way that it is, as I was going through, as I was looking through the process, reading through this, when it says that this is about adopting the policies that refer to firearms or rules or regulations that refer to firearms through the rulemaking process. Currently 541A exempts a list of different functions from rulemaking, and it also exempts internal policies from rulemaking. My reading of the intent of this has been all along that those policies come in. That is the exemption in 541A:1. That's 15, if I know my Roman numerals correct. And since if we're intending to include policies in this, we would want to notwithstand the exemption for those policies in this case. And then the long list of those who are exempted from rulemaking, which is the 541A:21. That was also one that otherwise we'd have some of these agents, we'd have some areas of law that don't come under this protective one where we're protecting people's rights. And there'd be
It's counterintuitive.
one class and
I think,
another
to
class.
keep these in here. Otherwise, how can we expect them to write rules if we say they're exempt from writing rules?
Which section are we talking about?
This is in 4B. So this would be in
Line 22. Yeah.
line, yes, and it would be inserting at line 24 where the period is to add a comma, notwithstanding exemptions from rulemaking in RSA 541A:115 and RSA 541A:21. If I know that we're working from one, but that language is written on lines 29 and 30 of page 2
Of the other.
of the other. Of the one we're not considering, but at least it gives us some written text.
Yeah. Does that make
So
sense
Rick,
to
if you
you?
look at the
Rick?
layout amendment on
Yep,
line-
I've got it.
yeah.
It makes sense because otherwise it makes this statute almost ineffective for those agencies because they're exempted. So what we're saying is they're not exempted just for this. Other rulemaking, whatever, they are still, but for this statute, they're not. Does that make sense?
Yes,
Okay.
I think it does.
So we're okay with adding that.
I haven't read those, the RSA's just referenced.
I know what you're referencing. So.
Senator Abbott, you have a very good counsel. I would suggest that you.
Well, we're relying on the advice of counsel, isn't always gonna happen. What I learned from this.
Okay, Erica next. And hopefully.
And then the rest was just around placement. Those were the concerns. I think the one thing that I do want to do, if we're not going to include the change to the Administrative Procedures Act, is ensure here today that we're stating that the legislative intent is that we are not going to allow JALCAR to sign off on something that does not follow this statute, specifically that it does not follow subparagraph 3. Sorry, which one is that? 4B, to ensure that we will not be granting exemptions to paragraph 4B through the JALCAR process, but instead we will, through the process of JALCAR requesting changes to the statute, move anything that needs to be cleaned up through that process where we understand that JALCAR has looked at this. We believe that this change should be made. We bring it to the general court. Usually that has an easier path forward than other laws and other statutes where it's not building off of a foundation. But I just want to have an assurance that there's not going to be, if I can disfavorably call it, an end run around the intention of this.
I would say that if we all agree and have a yes vote here, for the record, that the legislative intent of this is that state employees have no less rights than other citizens have under their right to self-protection under the New Hampshire and United States Constitution. And I'll repeat that from the well. And once the governor, God willing, signs it, I'll repeat it again. And I would ask my Senate colleagues if that is their understanding as well.
So again, Mr. Chair, I'm going to a little detail in here.
Well, to the extent
to
that-
the extent it's again, I think there, to your point, you had even raised, there are reasonable restrictions that might be necessary to the course of employment that need to come. But what we're saying here is that we recognize that, but if an agency wants that, they have to come before the legislature and ask for that, what that might look like, and have statutory authority to do it. We're not saying they can't do it. We're just saying they need statutory authority to
That's
do
correct.
it.
I think what my statement was and remains is that is our starting point. And if those rights need to be infringed in any way, it's incumbent upon the agency, it's their burden to show the legislature why they should be able to do that.
And so, Mr. Chair, again, as part of JALCAR, it's not uncommon that we'll turn to the lawyers and say, add that to our spreadsheet of list of laws we need to adopt and change. And every year they bring it, at the end of the year, they give it to us, and then we review those and we find sponsors for those bills that needed legislative change that was discovered through the JALCAR process. So I anticipate this would fall underneath that process.
Yes, agreed. Anyone else? Anything else? I think we have an agreement.
But we're not adding the paragraph I.
What?
We're not adding this section. Is that?
No, I believe we've had the assurances that I needed that JALCAR would not be themselves approving anything as a function of the general court, and that it needs to go through the statutory authority. That was a belt and suspenders to ensure that was the process. But given the assurances made today, I don't think that we need to add that section to the Administrative Procedures Act at this point. That may be a cleanup if this isn't actually affected the way that we're intending to today.
Okay, may I suggest then that we take a vote on what we've agreed to? And if we need to come back for some reason, I'm not going to close the session. If we need to come back at some point today to revisit something, we can, but let's vote that everything we've just talked about is what we agreed to. So,
Mr. Chair, if I may, real quick, just to summarize, make sure everyone's clear.
Sure, go ahead.
So again, we're going to strike the word person on page 1, Roman 3, letter A. We're going to strike the second word there, person. So it says no public official.
Go back up. We're also adding.
No, that's already in the Senate version.
Oh.
We don't need that because we're adopting the Senate version.
Okay.
And then we're going to add in, on page 2, I believe it is, line 24, we're going to add in that phrase is notwithstanding exemptions from rulemaking in RSA 541-A:1, Roman 15, and RSA 541-A:21 to list it at the end of that.
That's correct.
And I believe
That's
that
it.
was all the changes. But that's what we'll be voting on, and the
Yes.
committee report would reflect those 2 changes.
That is correct. And-
That is correct.
All right, so I'm gonna call the roll. Representative Paquette, yea or nay?
Yes.
Representative Leon?
Hold on, I was just checking to see. Sorry. I had one other one that I had not recognized in here. I was just
serious
looking
right
back
now?
to see. I'm serious.
Wait,
I'm sorry. I'm sorry. At the top of page 2 in B, it was any person or an organization whose membership is aggrieved by a violation of paragraph 3 in this section may bring action for damages. So one of the trends that we've been seeing in litigation is that there will be a plaintiff. There's a suit because their rights were violated, and some of the courts are saying that yes, we're granting this injunction for you, but not for anybody who is part of that lawsuit. By doing that and allowing any organization whose membership is aggrieved by a violation, we're dealing with less of an issue around that how the judiciary is deciding about who the injunction or who the ruling applies to.
Are you talking about an as-applied type of situation? What is?
Sorry, microphone's off.
Yeah.
The question is whether a group, an interest group that has an organization formed can have standing to litigate
the
themselves.
NRA.
Or what the NRA, environmental groups, voting rights groups do it all the time. And whether you want to try to confer standing on organizations like that is judgment call for y'all to make.
Yeah, that could also cause lawsuits by Second Amendment groups too. I'd rather not add that, open door, and just,
Okay.
if the NRA wants to represent someone, they can act as of counsel, I think, and then they have standing through a litigant, right? They just need a litigant.
There's pluses and minuses, but yeah, for
Yeah.
either side, but yes.
Yeah, so let's just,
Thank you for considering that.
yeah. Okay, was that it?
That was it.
Okay, so now that we didn't change anything, the vote is to you, yea or nay?
Yay.
And Representative Rhodes?
Yes.
I vote yes. Senators?
Yes.
Yes.
Thank you. Okay, we have an agreement and we will be on break. And,
We're done.
well, I think you guys want a
Consent.
minute, or are we good? I will. Okay, so I'm closing, wait a minute, any objection to consent?
None for me.
Okay, it will go on consent, and I hereby close the committee conference.
I thought you were doing a break just in case, or we're
No,
good.
they
We're
said
good.
go ahead.
Perfect.
conference. And this is, what bill is this? It's Bill
1279?
1279.
I'm in the wrong seat.
It doesn't matter, stay with here. So unfortunately, we could not come to an agreement with regard to the restraint provision. So the House would have to not concur with that. However, we are willing to accept the change the Senate made with regard to the use of force against a third party on your premises. If that's something you can agree to, then we're willing to do
So
that.
you will not agree to whatever was added to the underlying bill, but the underlying bill as passed by the Senate, the House will cede to the Senate on that.
And if you could, please explain that position for the public, what that underlying bill that the Senate passed is.
Although it's lost in my pile of papers, essentially, the law as written involves the use of deadly force. If you're on thank you. If you're on your property or in your home, you can use deadly force if someone's using force against you while committing a felony, but it's only if it's against the actor, which the person using the deadly force. You cannot use that deadly force to defend a third person. And I've always looked at that as, well, if someone was doing that to me, fine, but my children or my wife or whatever, tough luck. They would have to my wife would have to use the deadly force and my children would have to use it. It just makes, to me, like it's the castle doctrine, like you're in your castle and I think it should extend.
To all your subjects?
They,
I love that you got that.
whoever wants to come to my house with an invitation.
And to the extent, I mean, it's not everything the House wanted, because we do have concerns with regard to the defense when you're in a vehicle. We've seen people being yanked out of their cars around the country. And currently, you can use lethal force if the person has a deadly weapon. But if someone larger than you just grabs you and throws you to the crowd, you cannot defend yourself. Having said that, I agree, and the House will agree, that when you are at your home and someone kicks in the door and they don't have a weapon, they've committed the underlying felony of breaking into your home, you should be able to use deadly force against them, not just if they're attacking you, but to defend your family or whoever else may be in the home. So it's a small step in the right direction, and we agree to that.
So the motion is, so they're going to cede to the Senate position on the underlying bill, but not any of the hospital language or restraint language.
And that is with great regret. That's something we need to look at, and I'm willing to work on that. I feel like study committees, I'm not a big fan of them. This may be one that's necessary, and I'd be happy if we wanted to turn this into a study committee right now that we could work on, so we had some agreed upon language by September. We would be happy to do that.
I'm not sure if it's kind of a deviation from where it's at, but I think you and I both learned a lot about this. I know my colleague,
Yeah, I don't need a
Very
study
familiar.
committee. I can study things very well on my own, and I will do so and be happy to work on it. But did you want to say something?
we know who to call
Representative?
for information too.
Thank you, Mr. Chairman. I was just going to say some of the things that were brought up was there's a lot of confusion on the way the current law reads and or enacted, and I just thought maybe if all people to stay a study committee, please don't ever repeat this. I may deny it. This may be the situation where that was obviously sarcasm because I know it's recorded. This sounds it is very, very reasonably a situation where it would be necessary. We learned that, between this age and this age is a lot, where doctors are being called in from, hours, the amount of time that it's even allowed to happen for restraint. I was given a whole school in 5 minutes time. So I think this is an example of it would be great. And I know my colleague, Representative Kofalt, feel strongly about that as well, if we could make that happen.
Yeah, I just want to say, I think what we need more than study is education. And unfortunately, or fortunately, we have a 400-member House of Representatives. And it's not only the people on the committee, but it's the people who cast votes on behalf of their constituents need to be educated as well. So it's my understanding that during the public hearing, the federal law portion of this wasn't even really addressed. And that might have eased a lot of concerns at that point or brought forward other suggestions. So, but at this late hour, I can't educate 400 people. And so we're, like I said, unfortunately, we have to pass on that.
It will be back.
We will be back. So just to read for the record before we vote, we're going to accede to the Senate position on the underlying firearms protection, deadly force protection in the home, and the rest is cut. Is that correct?
That's the motion.
Okay, can I have a vote, please? Representative Copeland, yea or nay?
Yes.
Representative Rhodes?
Yes.
I vote yes. Do we have a fourth? Are you here? Are you on this committee? Okay.
It is now.
Yeah, Deputy Speaker Smith.
Yes.
Senate members?
Yes.
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 Okay. All right, with that, I will close the committee of conference. And yes? I would like that. Thank you. You have good ideas. Any objection to consent?
No.
Seeing none, it will go on consent, and I close the committee of conference. And I now open up the committee of conference on House Bill 194 that we broke from yesterday without a final resolution. During the preceding 24 hours, it's come to my attention that we're not going to be able to reach any kind of agreement on that.
Well,
Senator Abbas?
is so in regards to 504, I understand that policy passed in your chamber. It has to do with basically if we don't pass it, we're gonna have to repay $20 million, give or take, back to the federal government. So I think it's an important consideration. I mean, I think it was unanimous out of the House committee. So the issue with the policy, I think the only difference between the language in 504, there was one paragraph, and I think it was an amendment by Representative Leon that we're willing to agree to. So
Well,
the $20 million is a lot of money to pay back to the federal government.
I'll give you this. Let's take a 5-minute break, and I mean 5 minutes, and we'll come back and see if there's any possibility.
And there's no Senate rule that prevents us from handling this.
And what would it require on the Senate side? Nothing, other than just the vote?
We just have to vote to accept it.
Okay, all right, 5 minutes. committee conference on 194, and after discussion and much, let me
You want the
finish.
underlying bill still?
And after discussion with you and many other members, we are unable to come to an agreement on this bill whatsoever. And the the House does not accede. And
Would you agree to the underlying House bill, or is it just the 504?
we are agreeing to none of it, unfortunately,
Even the House bill?
even the House
As
bill,
written.
as written. And at this point, I am adjourning.
Read your sunglasses.